You know what nobody tells you in law school? That the job is about 60% reading things you didn't write, drafting things under time pressure, and explaining complicated stuff to people who just want a straight answer. The actual legal reasoning, the part they trained you for, that's maybe a third of it. The rest is just volume. And collectively, across this panel, we've spent a long time figuring out how to manage that volume without it managing us. This video is about the best thing we've found. Between us on this panel, we cover commercial litigation, construction, employment, tax, government work, and in-house practice. And one of the things we've all noticed across every area of practice and every level of seniority is that the lawyers who feel most stretched aren't stretched because the work is too hard. They're stretched because the work is relentless. There's always another document to review, another email to return, another client who needs a clear explanation of something complex, another brief that needs to be better than the last one. The cognitive load of this job isn't just the legal reasoning, it's everything around it. Claude doesn't fix that entirely. Nothing does. But used properly, it changes the ratio. It takes tasks that used to take 30 minutes and makes them take 5. It takes the blank page, which is one of the most cognitively expensive things a lawyer faces every day, and replaces it with something to react to. It turns preparation from something you scramble to do at the last minute into something you can actually do well, even when the week is full. Before we get into the practical stuff, we want to be clear about what Claude is and how it works, because there's a lot of noise around AI tools right now, and we'd rather set honest expectations up front. Claude works differently from a junior associate. A junior associate develops judgment over time, understands the culture of your firm, builds relationships with clients, and carries professional accountability for their work. We've got a whole separate series on working with Claude the way you'd work with a very capable associate, and it's worth watching. But for now, what's important to understand is that Claude brings something different. It's read more contracts, more case analyses, more legal correspondence than any person alive. It doesn't get tired, it doesn't have a billable rate, and it's available the moment you need it, at any hour. Claude isn't a search engine either. It doesn't retrieve documents or case law from a database. It reasons and generates, which means it can make things up. I'll come back to this because it's the most important thing to understand about working with it safely. And it isn't a magic button. If you type a vague request, you'll get a generic response. The quality of what comes out is directly proportional to the quality of what you put in. That relationship is non-negotiable, and it's why the first block of this masterclass is entirely about setup and communication. What Claude is, used well, set up properly, is the most capable thinking and drafting partner most lawyers have ever had access to. And when you learn to brief it correctly, it produces work that would take you significantly longer to produce alone. This masterclass covers 5 areas: setup, document work, drafting, preparation, and the business of running a practice. Each has immediate practical application, regardless of what kind of law you practice. By the end of this hour, you'll have the foundations. Everything more advanced builds from here. 2 things before we go further. First, and I can't say this clearly enough, Claude makes mistakes. It'll sometimes state a legal proposition with complete confidence that turns out to be wrong, imprecise, or only accurate in a different jurisdiction. There's a term for this, hallucination, and it's a real phenomenon. Claude doesn't know what it doesn't know. It won't flag uncertainty the way a careful lawyer would. For anything that matters, a citation, a legal conclusion, a date, a clause you're relying on, you verify against the primary source. This isn't optional. In a legal context, the consequences of not checking are professional consequences, and they're yours to carry, not Claude's. The good news is that once you internalize this, it's not actually a significant constraint. You're going to read the output anyway. You're a lawyer. Reviewing work before it goes out the door is what you do. Claude doesn't remove that step. It just makes everything that comes before it faster. Second, your bar association has guidance on AI use, and you need to read it. Most jurisdictions now have ethics opinions covering competence obligations around AI, confidentiality requirements when inputting client information into third-party platforms, and in some contexts, disclosure obligations to courts or clients. This video doesn't cover that guidance because it varies by jurisdiction and it's changing fast. Before you put client confidential material into any AI tool, including Claude, satisfy yourself that doing so is consistent with your professional obligations. That's a 30-minute exercise, not a year-long research project. Go do it. Those are the only guardrails. Everything that follows is about using this tool to its full potential. Most lawyers who try Claude and find it disappointing made the same mistake. They opened a chat, typed something vague, got something generic back, and concluded the tool wasn't useful. I understand that reaction. If the first thing you ask Claude is something like, summarize this contract, with no other context, what you'll get is a summary that reads like it was written for nobody in particular. Because it was. Claude didn't know who you are, what kind of lawyer you are, what your client needs, or what you're going to do with the output. The gap between a generic Claude response and a genuinely useful one is almost entirely about context. And the way you build that context isn't by adding more words to every individual prompt. It's by doing the setup work once, at the beginning, so that every conversation you have afterward already starts from a position of Claude knowing who it's working with. There are two things you need to do: create a project and write a system prompt inside that project. These two things together take about 15 minutes the first time, and they'll permanently change the quality of everything you get out of Claude from that point forward. When you open Claude without a project, you're starting every conversation from scratch. Claude has no memory of the previous conversation. It doesn't know you're a lawyer. It doesn't know your jurisdiction. It doesn't know your preferred file note format or the tone you use with clients. Every time you open a new chat, you're a stranger walking in off the street. A project changes that completely. A project is a persistent workspace inside Claude. You set it up once, you write your instructions once, you upload your reference documents once, and from that point on, every conversation you have inside that project starts with Claude already knowing everything you've told it. You don't repeat yourself, you don't reestablish context, you open a chat and you start working. Here's how to set one up. In the left sidebar of Claude, find the Projects section. Click to create a new project. Name it something that reflects your practice. Your firm name, your initials, or simply legal practice. That name is just for you. Then, inside the project, you'll see a field for instructions. That's where we're going next. One note on plans. Projects are available on Claude Pro and Claude for Teams. If you're on the free plan, this is the single biggest reason to upgrade. The difference in usefulness between Claude with a project and Claude without one isn't marginal. It's the difference between a tool that works for you and one you have to work around. The instructions field inside your project is called a system prompt. It's the foundation of everything. This is where you tell Claude who it's working with, what you expect from it, and how you want it to behave. Most lawyers leave it completely blank. That's the single most common setup mistake, and it's why most lawyers who use Claude are getting a fraction of what it's capable of. Let us walk you through what a strong system prompt actually looks like, and then we'll explain each part so you can adapt it to your own practice. Here's a starting template. You're working with a practicing attorney. I'm a commercial litigation attorney. My clients are primarily mid-market businesses, privately held companies, founders, and executives. I practice in California. When I ask you to draft anything, write in a professional legal register, unless I explicitly ask for something else. When I ask you to explain a legal concept, assume I understand the law. Give me the depth I can actually use, not a plain English overview designed for a non-lawyer. Flag any assumptions you've made in your response. Never present a speculative legal conclusion as settled authority. If you're uncertain about jurisdiction-specific rules, recent case law, or regulatory developments, say so explicitly, rather than guessing. Now, let me walk through what each piece of that is doing, because you need to understand it well enough to write your own version. The first line, "You're working with a practicing attorney," calibrates the entire register of everything Claude produces. Without it, Claude defaults to a general audience. With it, Claude knows it's not explaining legal concepts to a layperson. It's talking to someone who passed the bar, has handled hundreds of matters, and doesn't need jargon defined. The practice area and client description do two things. They tell Claude what kind of work is likely to come up, and they tell Claude what your clients look like, which matters when you ask it to draft client-facing communications. My clients are mid-market businesses produces a different email register than my clients are individuals going through family law proceedings, both correct for their context. The jurisdiction line is critical and often overlooked. Without it, Claude will often default to a blended general answer that may not accurately reflect the law where you practice. Specifying your jurisdiction doesn't mean Claude will always get it right. You still verify, but it grounds the responses in the right legal system. The instruction about flagging assumptions is one we consider essential. Claude will sometimes make an assumption to fill a gap in what you've told it. If you ask it to draft a demand letter without specifying the governing state, it'll pick one. Without this instruction, it may not tell you it did that. With it, Claude will surface those assumptions so you know where to check. Once you've got this foundation, you can add layers specific to your practice. If you handle a lot of file notes, add your preferred format. When drafting file notes, use this structure: date, attendees, matter reference, matters discussed, instructions received, follow-up actions, and responsible party. If you want Claude to challenge your thinking, when I'm working through a legal problem, don't simply agree with my analysis. Identify weaknesses and anything I may have missed. Take 15 minutes after this video and write your version of this. It doesn't need to be perfect on the first pass. You'll refine it over time as you learn what's missing. But even a rough first version will immediately improve everything you get from Claude. Projects also let you upload documents Claude will reference in every conversation: your standard engagement letter, your file note template, your preferred clause library. Upload those once, and when you ask Claude to draft an engagement letter or a file note, it's already got your template. It doesn't produce a generic version, it produces something that looks like your work. This is the most important skill in this entire masterclass. Everything else we cover in the next 50 minutes depends on getting this right. Most lawyers come to Claude and type the way they'd type a search query: short, keyword-based. Draft a demand letter. Summarize this contract. Those prompts will produce responses, but they'll produce generic responses because they contain no information about your specific situation. I want you to change the way you think about this. When you engage Claude, don't think about typing a search query. Think about briefing a colleague. Specifically, think about briefing a very capable colleague who's brilliant and well-read, but who's completely new to your matter and knows nothing about it that you haven't told them. When you brief a colleague before they draft something for you, you don't say, "draft a demand letter." You tell them who the client is, what the dispute is, what's already happened, what outcome the client wants, what tone is appropriate, and what constraints apply. You give them context. You give them the background they need to produce something useful on the first pass. That's exactly how you need to brief Claude. And here's the important thing: it doesn't take long. The difference between a 2-word prompt and a useful brief is 30 to 60 seconds of additional typing, but the difference in output quality is significant. Here's what this looks like in practice. Week. Draft a demand letter. Stronged a letter of demand on behalf of my client, a commercial painting contractor based in Los Angeles. The respondent is a general contractor who owes my client $42,000 for completed work on a commercial building project in Santa Monica. The work was completed and accepted in March. We've got a signed subcontract and a completion certificate. My client sent 2 emails requesting payment, both ignored. No dispute's been raised about the quality of the work. The tone should be firm and professional. We want to make clear that legal proceedings will follow if payment isn't received within 14 days, but we're not trying to blow up the commercial relationship. My client works with this contractor regularly and wants the money, not a fight. 1-page maximum. Both prompts ask for the same thing. The first will produce something generic that requires substantial rewriting. The second will produce something close to sendable on the first pass. The second prompt took about 45 seconds to type. That's the trade. Before you submit anything to Claude, ask yourself, have I told it who the client is, what the matter is, what I want it to produce, what tone is appropriate, and what constraints apply? If the answer to any of those is no, add the information before you submit. Lawyers read documents all day. Contracts, affidavits, disclosure statements, judgment transcripts, lease agreements, due diligence packages, expert reports. This is one of the most time-intensive parts of practice, and the cognitive load is high because reading a legal document properly isn't passive. You're simultaneously parsing the language, identifying what's unusual, tracking what's missing, and thinking about what it means for your client's position. Claude doesn't replace that analysis, but it can do the first pass for you. It can flag the things that are unusual before you've read the whole document. It can extract specific information so you don't have to search for it. It can compare two versions so you're not doing a manual redline from scratch. And it can translate a complex document into something a client can actually understand. Document work is where most lawyers start with Claude, and for good reason. The time saving is immediate, and the risk is manageable because you're always reviewing the output against a document you've got right in front of you. In any Claude conversation, you can upload a PDF, a Word document, a plain text file, or paste text directly into the chat. For most legal documents, PDF upload works well. For very long documents, anything over 50 to 60 pages, be aware that Claude has a context limit, which means there's a ceiling on how much text it can process in one conversation. For most day-to-day documents, you'll be fine. For very long transactional documents or large due diligence packages, break the task into sections. The first and highest frequency use case is summarizing a document for a client. You've got a 20-page commercial lease. Your client's a small business owner who's never signed a commercial lease before. They need to understand what they're agreeing to before they sign. You need to give them something they can actually read and act on. Not the lease itself, not a legal memo with headings and footnotes, but a clear, plain English explanation of what this document means for them. Writing that from scratch takes time. It requires you to read the whole document, identify the key provisions, translate them into plain language, and structure the explanation in a way that a non-lawyer can follow. It's important work. It's also exactly the kind of work that gets done less thoroughly than it should when you're trying to get through a full billing day. Here's how to approach it with Claude. Upload the document, then type something like this. Please summarize this commercial lease for my client. My client's the tenant, a small retail business owner who hasn't signed a commercial lease before. Focus on their key obligations under this lease, the main financial commitments and how they work, anything they'll need to do or decide before signing, any provisions that are unusual or that I'll need to explain to them separately, and any significant risks they should be aware of. Write this in plain English. No legal jargon, or if jargon's unavoidable, explain it immediately. Aim for 2 pages. What comes back won't be perfect. Read it. You'll catch things that need your professional gloss. But the structure will be there. The key provisions will be identified, and you'll be editing rather than drafting from scratch. For a document review that might otherwise take 40 minutes to summarize properly, you're now looking at 10 minutes of editing. The second use case is red flagging unusual or risky clauses, and this is where Claude adds a qualitatively different kind of value. You're reviewing a commercial contract on behalf of your client. You want to know where the risk is. You want to know what standard protections are missing. You want a map of the issues before you sit down for the careful read. Here's the prompt structure that works best. Please review this agreement and produce a red flag checklist. I'm acting for the party described as the service provider. I need you to identify, first, any clauses that are unusual or that depart significantly from what you'd expect in a standard services agreement of this type, with a brief explanation of why they're unusual. Second, any provisions that are particularly favorable to the other party and that I should consider pushing back on in negotiation. Third, any standard protections for my client that appear to be absent from this agreement. For each item, note the relevant clause reference so I can find it in the document. What you get back is a working checklist. Use it to orient yourself before you read the document in full. It ensures that when you sit down with the contract, you're already oriented to where the issues are, reading with a map rather than starting cold. We want to be direct about the professional responsibility point here. The red flag review is a tool for your first pass, not your only pass. It supplements your own careful read. It doesn't replace it. Use it to catch things that are easy to miss in a long document when you're moving fast, but the final read is still yours. The third use case is comparing two versions. Paste or upload both versions and ask Claude to compare them. I'm going to give you two versions of a distribution agreement. Version 1 is the draft we sent to the other party. Version 2 is their markup. Please compare the two versions and identify every substantive change. Ignore formatting and punctuation differences. For each substantive change, tell me what was changed, in which clause, and whether the change appears more favorable to the distributor or the supplier. Flag any changes significant enough that I should push back, with a brief explanation of why. For a document that might take 45 minutes to redline manually, you've got that structured summary in under 2 minutes. And the fourth use case is extracting information at volume. If you've got a set of documents and need the same class of information from each, payment terms, governing law clauses, expiry dates, Claude can do that systematically and present the results in a table. Due diligence packages, lease portfolios, employment agreement reviews, anywhere you'd otherwise spend an afternoon on a manual extraction exercise. Drafting is where lawyers spend more of their time than almost anything else, and it's the most cognitively demanding part of the job. Not because the individual tasks are hard, but because drafting requires you to hold multiple things in your head simultaneously. The facts of the matter, the legal framework, the client's instructions, the relationship with the other side, the appropriate tone. And you've got to hold all of that while producing coherent, precise prose. Claude doesn't hold all of that for you. You still have to know the matter and exercise the judgment, but it radically reduces the friction of getting started, the blank page problem, and it takes on the structural work of drafting, so your cognitive bandwidth goes to the judgment work that only you can do. Every drafting task follows the same pattern. You give Claude the context, you tell it what you need, it produces a first draft. You review it and improve it. The quality of the first draft depends on the quality of the brief, and improving a solid first draft is significantly faster than building from zero. This is the workflow we recommend to every lawyer who asks us where to start with Claude, because the return on time invested is immediate, and the risk is essentially zero. Here's the situation. You've just finished a client call. You've got raw notes in front of you, probably a combination of complete sentences, half-finished thoughts, shorthand only you understand, and a list of things you promised to do. Normally, turning those notes into a proper file note takes 15 to 20 minutes of focused effort after what was already a demanding call, and it competes with everything else on your desk. Here's what you do instead. Open Claude. Type this. These are my rough notes from a client call that just finished. Please draft a professional file note based on these notes, using the following format: date, attendees, matter name, matters discussed, client instructions received, and follow-up actions with responsible parties noted. Flag anything in my notes that's unclear or where you've had to make an assumption to fill a gap. Then paste your raw notes exactly as they are. Don't tidy them up first. That's the whole point. Claude handles the translation from rough to professional. What comes back will be 90% of the way to a finished file note. Read it carefully, correct anything that's wrong, add anything that was in your head but didn't make it into your notes. Sign off on it. Total time from call end to completed file note, 5 minutes instead of 20. The reason we describe this as low risk is simple. The file note goes into your system, not out the door. You're reviewing it against your own recollection of the call and your own raw notes. If Claude's made an error or an assumption, you'll catch it. Let me walk you through a demand letter brief in detail, because this illustrates exactly how the briefing principle works in practice, and demand letters are something almost every lawyer drafts regularly. Here's a complete brief. Draft a letter of demand on behalf of my client. My client's a commercial interior design firm based in Chicago. The recipient is a property developer who contracted my client to design and oversee the fit-out of 3 retail tenancies in a new development. My client completed the work in full. The developer accepted the completed fit-out without raising any defects. The final invoice, $48,000, has been outstanding for 93 days. We've sent 2 written payment requests by email. No response has been received. No dispute about the work or the invoice has been raised. My client wants payment. They're not interested in negotiating a discount or a payment plan. They want the full amount within 14 days. They're prepared to commence proceedings if payment's not received. Tone, firm, professional, and unambiguous. Don't threaten, state the consequence clearly. 1 page. That brief took about a minute to type. What Claude produces from it will state the facts clearly, reference the outstanding amount, specify the deadline, and state the consequence. You read it, check the facts are accurate, adjust the tone to match your firm's voice, add your letterhead, and send it. Total time, 8 minutes instead of 30. The same principle applies to engagement letters, briefs to counsel, and internal matter memos. If you've uploaded your standard engagement letter template to your project, which you should, you can ask Claude to adapt it to a new engagement in seconds. Give it the client, the matter, the fee arrangement, the retainer, the scope. It produces your template adapted to these specifics. You check it, sign off, send it. For briefs to counsel, give Claude the facts, the legal issue, the evidence you have, and the specific questions you need counsel to address. What comes back is a structured brief that gets counsel oriented quickly and asks the right questions. Counsel's time is expensive. A well-structured brief is worth significantly more than a document dump with a covering email. And for internal matter memos, when a file changes hands, when a partner needs updating, when you're picking up something you haven't touched in 3 weeks, give Claude the key facts and developments, the current status, and the next steps. Tell it who the audience is. The memo it produces is the structure you correct and refine, not the document you build from nothing. This is the block we find most underestimated by lawyers who are new to Claude, and the one that, across all of our practices, produces the most meaningful shift in how people feel about their workday today. Preparation is one of the most cognitively expensive things a lawyer does. Before a hearing, you're trying to anticipate the bench. Before a negotiation, you're trying to model the other side's position. Before a first meeting with a new client, you're trying to get oriented in an industry you may not know well. Before a difficult client conversation, you're trying to think through the dynamics before you're sitting in the room having to manage them in real time. This work is important. It's also the work that gets squeezed when the week is full, because it doesn't have a deadline attached to it, the way a filing or a contract does. Claude is exceptionally well suited to preparation work. What it does, modeling scenarios, identifying gaps, surfacing arguments you hadn't considered, is essentially what good preparation requires. And it's available at any hour, which matters when your best preparation thinking happens at 11 at night. Directions hearings are often treated as low-stakes administrative events. For many of them, that's accurate, but they can turn quickly. A judge who's got a view about the timetable, an opposing party who raises something unexpected, a procedural issue you hadn't flagged. Being caught flat-footed at a directions hearing is embarrassing in a way that's disproportionate to the event. Here's how to prepare with Claude. I've got a directions hearing tomorrow morning. Here's a brief summary of the matter and where we are in the proceedings. Paste 3 to 5 sentences. I'm seeking, describe the orders you want. The other side's likely to resist, describe the expected opposition. Please give me, first, the questions I'm most likely to be asked from the bench, with suggested responses for each. Second, any procedural issues the other side might raise that I should be ready to address. Third, anything I should proactively bring to the court's attention before being asked. Go through that output the night before. Formulate your answers out loud if you can. You'll walk into that courtroom prepared for what's likely to happen, rather than hoping nothing unexpected comes up. The same principle applies at trial. The week before a trial is one of the most overwhelming weeks in a lawyer's professional life. Documents, witnesses, submissions, logistics, and 100 small things all competing for attention. Claude won't replace the substantive preparation work, but it's an excellent thinking partner for structuring your approach and identifying what you haven't yet addressed. Brief it with the matter, the key factual issues in dispute, your client's position, and the other side's position. Ask it, what are the most important issues I need clear answers to before we go in? What are the weaknesses in my client's position that I need responses to? What are the strongest points in our favor that need to come through clearly? What are the likely cross-examination lines for my key witnesses? That output is a preparation checklist. Work through it. Add what's missing. And we'll say this. The act of articulating the matter clearly enough for Claude to engage with it will itself clarify your thinking. Writing a clear brief to Claude is also a thinking exercise. You'll often catch something in the process of writing the prompt that you hadn't noticed before. For new client meetings in industries you're less familiar with, Claude can orient you in 30 seconds. I'm meeting tomorrow with a new client who operates a small regional freight logistics company with about 40 employees. I'm a general commercial lawyer. This isn't a sector I know particularly well. Please brief me on the most common legal issues that arise in this industry, covering employment and contractor classification, regulatory and licensing requirements, contract structures with customers and carriers, liability exposure, and anything else a commercial lawyer should have front of mind walking into a first meeting. Keep it practical. I need to know what questions to ask and what problems to look for, not a comprehensive treatise. You're not relying on this for client advice. You're using it to orient yourself so the first meeting is useful rather than generic. It takes Claude 30 seconds to produce a briefing that would have taken you an hour to research yourself. You'll ask better questions, you'll spot the relevant issues faster, and you'll come across as someone who understands their world well enough to add value to it. For negotiations, brief Claude with the commercial context, the key points in dispute, your client's objectives and real constraints, and ask it to model the other side's likely positions and the commercial logic behind them. Ask it where your client will need to show flexibility to get a deal done. Ask it what you should be trying to understand about the other side's priorities during the negotiation itself. Going in having already thought through the probable counterarguments is a material advantage, and it's the part of preparation most lawyers skip when time is short. And for difficult conversations, a client who's unhappy with an outcome, a partner you need to push back on, delivering news that changes someone's plans entirely. I need to have a difficult conversation with a client tomorrow. The situation is, my client expected this matter to settle for around $200,000. I've received an offer of $75,000, and based on my assessment of the merits and the costs risk, I believe they should take it. My client's likely to react badly. They've invested emotionally in this litigation and believe they've been wronged. Help me think through how to open the conversation clearly and honestly without immediately triggering a defensive reaction. How to explain my recommendation in a way the client can actually hear rather than dismissing it because they're upset. How to address the objections they're most likely to raise, and how to close in a way that preserves the relationship and my ability to advise them effectively if they decide not to follow my recommendation. This isn't a script. You're not going to read from it in the meeting. It's a thinking exercise, a way of working through the dynamics of a hard conversation before you're in the room and trying to manage them in real time. The lawyers who use Claude for this kind of work tell us consistently that it changes how they feel walking into difficult situations. Not because the conversation becomes easy, but because they've already thought through the likely moves. They're not caught off balance. The fifth block is different from the others. Everything so far has been about legal work, the documents, the drafting, the preparation. This block is about the business of running a practice, the communication work, the knowledge management work, the things that matter to the health of your practice, but that consistently get deprioritized when billing pressure is high. These are tasks Claude handles particularly well because they require good writing and clear thinking rather than legal judgment. And they're tasks where the time investment is low and the return in client satisfaction, in firm efficiency, in the quality of your practice is disproportionately high. Clients who don't understand the process become anxious clients. Anxious clients call more. They second-guess decisions. They need more hand-holding at every stage. They're harder to work with, and they're more likely to be dissatisfied with the outcome, even when the outcome is good, because they didn't understand what they were signing up for. A plain English process explainer, a 2-page document that tells a client what's going to happen, when, what they need to do, and what to expect, is one of the highest value things you can send a client at the beginning of a matter, and Claude can produce a solid draft in 30 seconds. Draft a plain English explainer for a client who's about to go through a commercial mediation for the first time. The client's the claimant, a small business owner with no legal background and no prior experience of dispute resolution. The document should cover what mediation is and how it differs from going to court, what'll happen on the day, what the client needs to prepare, what role I'll play as their lawyer, what the likely outcomes are, and what happens if we don't reach a settlement. 2 pages maximum. Plain English throughout. No jargon without explanation. Review it, personalize it to your client and your matter, and send it with your next client update. The client who receives that document has a fundamentally different experience of the matter than the client who doesn't. When a relevant judgment comes down, a case that affects your client's matter, or a significant development in an area of law relevant to their business, you want to communicate what it means to them. Upload the judgment or paste the relevant sections and ask Claude to summarize it for a non-lawyer client. What the court decided, why, and what the implications are for someone in a similar position. That summary takes 30 seconds to generate and 15 minutes to review and refine. Send it to the client with a brief covering note. They'll remember that you sent it. That's relationship building at a cost of 15 minutes. If you're in a practice area where you see the same client questions repeatedly, and every lawyer is, a FAQ document is one of the most efficient things you can create. Draft it once, refine it over time, and use it on every new matter in that area. Draft an FAQ document for a new client who's just engaged me for a residential property purchase. Cover the 15 questions that first-time buyers most commonly ask during the conveyancing process. Questions about the timeline, the costs they should expect beyond my fees, what searches are and why they're done, what happens at exchange and settlement, what I need from them and when, and what to do if something unexpected comes up. Answer each question in plain English in 3 to 5 sentences. The document should feel reassuring and informative. Review it, adjust it for your jurisdiction and your practice, and you've got a document that saves you 15 minutes on every new property matter intake call. Over the course of a year, for a busy conveyancer, that's a material amount of time. And if you supervise junior lawyers or paralegals, Claude can save you significant time in knowledge transfer. Instead of verbally explaining how to approach a task and hoping the explanation lands, produce a written checklist or workflow guide. Draft a checklist for a junior associate conducting initial due diligence on a commercial property acquisition. The checklist should cover the documents to request from the vendor, the key issues to look for in each document category, the searches that need to be conducted and what they reveal, the red flags that should be escalated to me immediately, and the standard questions to put to the vendor's solicitors in the initial inquiries. Assume the associate's capable but hasn't done a commercial property acquisition before. Review it against your own practice. Add what's missing. Remove what doesn't apply. You've now got a document you can hand to every associate who joins the team, rather than explaining the same things from scratch each time. 6 things we want you to take away from this hour. Set up your project and write your system prompt before you do anything else. Everything I've covered in the last hour works significantly better when Claude already knows who you are and how you work. This is the 15 minutes that pays dividends every time you open the tool. Do it today. Brief Claude the way you brief a capable colleague. Give it context. Give it purpose. Give it the background it needs to produce something useful. The difference between a vague prompt and a proper brief is 30 to 60 seconds of additional typing. The difference in output quality is significant. This is the most important skill in this entire video. Start with document work if you want a fast win. Summarizing a document for a client, running a red flag review, comparing 2 versions of a contract. These are high-frequency tasks where the time saving is immediate and the risk is low because you're always reviewing against a document you've got in front of you. Start here, build the habit, and expand from there. Use it for preparation. This is the use case most lawyers discover last and value most over time. The hearing prep, the negotiation modeling, the new client briefing, the difficult conversation rehearsal, these are the tasks that change how confident you feel in the moments that matter. Start small. Brief Claude before your next directions hearing. See what it surfaces. Build it into your preparation routine. Verify everything that matters. Every citation, every date, every legal conclusion, every number. Claude isn't infallible, and in a legal context, the consequences of not checking are yours. This isn't a reason to avoid the tool, it's a reason to use it with the professional discipline you bring to every other aspect of your practice. Read your bar's guidance on AI once, properly, before you put client confidential material into any AI tool. It'll take 30 to 60 minutes. It'll give you the framework you need to use these tools confidently without professional risk. The PDF that goes with this video has every prompt template I covered today, formatted, ready to copy, with the bracketed fields clearly marked so you can fill them in for your matter. The link's in the description. Download it. Keep it open the first few times you use Claude. The prompts are starting points. You'll adapt them over time as you learn what works for your practice. One last thing. The lawyers who get the most value from Claude aren't the ones who use it the most. They're the ones who use it deliberately. They know what they're trying to produce. They brief it properly. They review the output with professional judgment. They treat it as a capable tool in the hands of a capable lawyer, which is exactly what it is. The foundations are what we covered today. Every more advanced application of Claude in legal practice builds from this. The tool's capable of significantly more than what we covered in this hour, but none of it works well without the habits and the setup that this hour is designed to establish. Good luck. Go use it.